I am Fatima Nasrin. In this video, we are going to do the analysis of polity questions of Prelims 2022. So, out of 100 questions, around 11 questions were asked from the polity, and most of the questions were directly from the static area, but there have been a current affair associated with that particular topic. So that is why they have asked that particular question from that particular topic. Okay, so now let's see what are the questions and let's try to analyze. Okay, so the first question is, the first question is regarding the Contempt of Court Act or Contempt of Court. So if you have read the newspaper, you might have come across the Contempt of Court in various occasions. So yeah, that's why they have asked. So it is a static topic. It is a very important static topic, and there have been current affairs. So that is why they have asked this question regarding Contempt of Court. So this is a fourth statement question, and so let's see. So the first statement is talking that, or is saying that this Contempt of Court Act 1971 was passed based on the recommendation or report of the committee called H.N. Sanyal Committee. So if you don't know that statement, just wait. Move on to the second statement. Then, the Constitution of India empowers the Supreme Court and High Court to punish for the Contempt of Court. So if you have read the newspaper, you might know that who punishes, or the news might be like this, the Supreme Court punishes for Contempt of Court or High Court punishes for Contempt of Court. So if you have read that, then obviously if you know, then if you know the statement is correct, then you can eliminate two options. Again, if you have confusion whether High Court issues or punishes for Contempt of Court, then hold on, move on to the next statement. This is Constitution of India defines civil contempt and criminal contempt. So if you have watched my current affairs plus program in our of our Ekam IAS, I have mentioned it many times that this is one of the trap by the UPSC, that they either say it is defined in the constitution or according to the Indian constitution, something like that. So it is not mentioned in the, or it is not defined, sorry, it's not mentioned, it is not defined in the constitution. So if you know that statement is wrong, again, so if you don't know the second statement, but if you know that this is not defined, then two statements is again eliminated. Alright, if you don't know, even if you don't know the first statement or second statement, from this you know that either one or two, both these two statements are correct. You only have to know fourth statement. See, that is what you are doing, the advantage of doing elimination or by going off statement by statement. Alright, so the fourth statement, obviously you have to know the statement, that is for making a law, who has the power to make a law. It is Contempt of C. First statement itself is saying that Contempt of Court Act 1971 was passed. So it is an act. If you don't know the committee, but it is an act, right? So it has to be passed by Parliament, right? So if you know that, then option B is your answer. So it is all mentioned in our material as well as the Contempt of Court is not being defined. It is mentioned in our material. Then again, see, we have discussed all these things, civil contempt, criminal contempt, all these things. See, here I have specially mentioned that Contempt of Court Act defines both civil and criminal contempt. It is not the constitution. Alright? Okay. So, I hope this question is clear. So, let's move on to next question. So, this was a new topic or new area related to advocates, bar councils. So answer of this question is not finalized. So I'm not going to discuss this question. We'll discuss once we get a solid answer. All right. So let's move on to the next question. Okay. Another very important area, constitutional amendment bill. So it is a very important static area, and lots of current affairs happened related to constitutional amendment bill. So what they have asked is simply the important conceptual area, whether it requires a prior recommendation from the president. Then president has to mandatorily, or president is obliged to give assent to the constitutional amendment bill. Then both house has this equal power regarding constitutional amendment bill. It has to be passed in both houses with special majority. So these are the important or the major key features regarding constitutional amendment bill, whether joint sitting is there for constitutional amendment bill. So when you study constitutional amendment bill, you have to know all these things, right? So what all things you know? Whether president's prior recommendation is required for amending constitutional amendment bill? No. So if you know first statement is wrong, you already got your answer. It is B. In case of constitutional amendment bill, the president has only the option to ratify the bill passed by the parliament. Alright. Okay. So we have also asked a question related to this, like joint sitting, in our prelims test series. So if you have solved this question, you might be, this question might have been easy for you. Alright. Okay. So that is why you have to see whether the question was asked related to a current affair, but it is an important static topic and they have asked questions from the static area itself. Okay. Then let's move on to next question. This is regarding the cabinet ministers or cabinet ministers, council of ministers, etc. Again, the same trap. The Constitution of India classifies. What they can do. See, if you have to know these kind of trap. I have mentioned this trap in our current affairs plus program classes, and I have shown the previous year questions. So if you have watched that video, you might have made this question correct. So it is not the constitution. This is our material. Constitution does not lay any provisions. So if you have read the material, then you might directly strike this question or this option as wrong. Then total number, again it is through the 91st Amendment Act that there shall not be, the strength shall not exceed 15%. So this is a correct statement. So we got the answer as B2 only. Alright. I hope it's clear. Let's move on to next question. This question is regarding the special powers of Lok Sabha. So there have been a lot of questions, previous year questions regarding the special powers of Lok Sabha or either special powers of Rajya Sabha. So yeah, so you have to know, if you have solved the previous year questions, you might know that it is an important area, and so it is covered in our material as well. So let's see. First statement is regarding ratification of declaration of emergency. Second statement is no confidence motion. Again, this is a very important. UPSC have asked this statement in different ways in its previous years. Like you know that the Council of Ministers are directly or collectively responsible to the Lok Sabha. So it has to be a no confidence motion, is like showing that and the no confidence motion has to be passed, or it can be passed only in the Lok Sabha. So it is the it is no confidence motion can only be passed in Lok Sabha. It is one of the exclusive powers of Lok Sabha. So if you know second statement is correct, then you can eliminate two statement. Then with that you don't have to read the third statement. It is nowhere in the option. So declaration of emergency. Emergency is very important, and again lot of current affairs have happened regarding emergency, proclamation of emergency, who declares. So when you study who declares, what is the procedure, what are the criteria, all those things you have to know. So if you know emergency, or if you have studied emergency, you might know that both house has equal power and both house has to pass with special majority, pass the emergency with or ratify with special majority. Alright. So it is, both house has same power. So it is not an exclusive power of Lok Sabha. So with that our answer will be 2 only. I hope it's clear. Let's move on to next question. Yeah. Anti-defection law. Very, very, very important area. Static current affairs. In both cases it is very important. Current affair related question, but from a static area. First statement is, nominated legislator cannot join a political party within 6 months. This is one of the key feature. A nominated legislator can join a political party within 6 months. That is one of the exception from anti-defection law. If a nominated person joins within 6 months, he or she will not be disqualified. But after 6 months, they will be disqualified. So, this statement cannot join, that is a wrong statement. So, with that, elimination, 2 statement gone. Then 2 options gone. Then time frame, this was the current affair. Supreme Court, Supreme Court made statement that within 3 months cases has to be solved regarding anti-defection. But it is because of this no time frame for clearing anti-defection law, there have been lot of pending cases regarding anti-defection law. Okay, so that is why these questions were asked. So we have covered it in our static area. We have asked questions in our test series. Also we have covered this in exclusively in our current affairs plus program. Okay, so answer will be 2 only. Alright, next question, Attorney General. So again, Attorney General, another static area, important constitutional body. So you must know that it is directly mentioned in the syllabus, that is the constitutional body. So Attorney General, it is the only of, they are and Solicitor General are the only officers. No, they are not. So if you know first statement is wrong, then 1, both. And according to the Constitution of India, again, according to the Constitution of India, Attorney General, who appoints, again if you don't know whether it is mentioned in the Constitution, then who appoints the Attorney General? It is the President. So, answer will be B. It is saying that government, right? The Attorney General submit resignation to the government. Who appoints him, right? Okay, so answer is D, neither. Both the statements are wrong. Next, mandamus. Again, fundamental rights, important, very important. 32, Article 32, very important. Writs, one of the important writs, mandamus, habeas corpus, mandamus. All these things are very important. We have asked a question in our prelims test series, as well as we have holistically covered in our materials. So, it is very important. You should know mandamus, the features. You have to compare prohibition, certiorari, habeas corpus, mandamus, everything. So, answer is, so it is against public. So, if you know that it is issued against public authorities or public office, then you can eliminate. So, it will not lie against private organization unless it is entrusted with public duty. Yeah, that is any public PSUs or public offices. Then it will not lie against a company even though it may be under government company. So, we know that this again issued against a public authority, then with that all the 3 statements are eliminated. C is the answer. So, that is regarding mandamus. So, we have covered this in our test series. So, if you have solved these questions, then and also UPSC previous year questions, you might it is an easy question. So, if you know that it is issued against government authority, you already got the answer. Then next question, very important. See, if you see all these questions, there is no wonder, these are all static area but asked due to a current affair. Okay, regarding deputy speaker, we have covered it in our current affairs because it was in the current affairs. It was in news for a very long time, And yeah, so first question, it is as per the first statement, as per the rules of procedure conducted in Lok Sabha, election of deputy speaker shall be held on such days as the speaker may fix. If you don't know, next question, it is there is a mandatory provision that election of candidate as deputy speaker of Lok Sabha shall be from either principal opposition party or a ruling party. If you have confusion, go to next question. The speaker has the same power, a deputy speaker has the same power as that of speaker when presiding. If you know that statement is true, then what you have to do? One statement, elimination of one statement. Then again, a well established parliamentary practice regarding appointment of deputy speaker. See, this is, if you read this statement, a speaker and duly seconded by prime minister. From there itself, you can just directly eliminate the fourth statement from the option, right? So we are stuck with first statement and A and B option. In that both there are 1 and 3. So we have to know whether 2 is correct. So it is a mandatory provision that what candidate deputy speaker, it is coming from either principal. Is there any mandatory provision like that? No. So option is A. Okay. Okay. So the last question regarding the fifth schedule. Fifth schedule of the constitution. If you, again, schedules are very important. A lot of previous year questions asked from fifth schedule itself, and also schedules, very important area. So directly fifth schedule under article 244 clause 1. Again, these are areas inhabited by tribes specified as scheduled tribes, and so it is regarding from this option is, it would prevent or it would prevent the transfer of land of tribal people to non-tribal. So this is the answer. Okay, so I hope this video was beneficial for you. I hope you have made most of or all the questions correctly. So these were the questions asked in the 2022 prelims from Polity. So I hope this video is helpful, and all these questions or all the questions were asked from the important areas, statistically important areas, and these were asked because of a prominent current affair. So it is your duty to study these topics. So I hope the analysis is helpful. So if you want further updation, please subscribe to our YouTube channel. And once again, thank you for watching this video. Thank you.